All right, good afternoon. Sorry for the short break for those of you who are returning from the earlier meeting today of the Bar Advisory Group meeting. We are now in the second half of our two-agenda day to conduct a public workshop on storage and towing fees and regulations attributed to our regulatory authority over automotive repair dealers. My name is Patrick DeRay, Chief of the Bureau of Automotive Repair, and I want to welcome all of you who are attending in person. This is a new building that you're within the Department of Consumer Affairs. For some of you who've never been to this facility, it is part of the DCA family, with most notably the Medical Board of California and its staff occupying some of the building space, as well as some other programs at the Department of Consumer Affairs. And we want to thank them for opening up their facility to our cause today, which is specifically the workshop, as well as the Bar Advisory Group meeting held earlier today. This, by way of background, and Matt's going to get into it as well, our presenter today, Matthew Gibson, came about as a result of legislation last year that was signed into law. It was the Bureau's Sunset Bill, which is the operational review of the Bureau of Automotive Repair that's done every 4 years, and the statutes were changed or modified to give the Bureau of Automotive Repair authority to regulate code sections that have traditionally not been within our authority to regulate. Our authority is limited to 2 areas: the Business and Professions Code and the Health and Safety Code for the operations of the smog check program. So diving into some of the provisions of other code sections is always problematic if we try to apply it to the automotive repair industry, unless there's somehow a link to the Business and Professions Code, for example. But that's can be somewhat of a challenge to make that link to our provisions. And that was the case when we attempted regulations to regulate storage fees being charged by automotive repair dealers, mostly in collision repair and vehicle theft recovery issues where the vehicle is being repaired. Storage fees come up quite a bit as a result of a repair transaction, or maybe not a repair transaction. And we attempted regulations a couple of years ago, I think it was, and we were told by our legal counsel, you do not have authority to do this. So we got that authority in our sunset bill last year. That bill, AB 1263, as I said, was signed into law, and we had the ability to work and develop regulations as early as January 1 of this year. We started off with providing some guidance. We thought, let's dive into this a little, not so quickly, and let's get some feedback from our stakeholders, namely the auto repair industry, also the third-party payer or insurance industry. And we did get some input on a guidance document that was ultimately published in January of this year, somewhere around the mid to latter part of the month. That document's been out and posted on our website since that time, so a little over 3 months. I've gotten a little feedback on it. It is kind of a living and breathing document. We have amended it at least on one occasion that I'm aware of, and it does have an update date as a result, and it was based on some comments we had received from one of our stakeholders. We haven't mentioned yet the California Department of Insurance. So that was sort of some good comments and feedback that they had provided to us in their review of the document. Our regulations that are before you today are pending review at the Department of Consumer Affairs. We've elevated them up for consideration and review by legal counsel. They are mirrored well, not mirrored exactly, but they are taken, a lot of the language is taken from that guidance document that's been up on our website since January. And there's some additional provisions that we've added that we found out about the need to include that aren't necessarily reflected in the guidance document. So I want to make sure everyone was aware of that. It is just a first draft, well, maybe now our second draft, but really I'll call this our first draft with this newfound authority that has been provided to the Bureau of Automotive Repair to address storage fees and how they're charged and assessed by automotive repair dealers. Diving into vehicle code sections that we did not have authority to deal with in the past, the civil code, and perhaps even some of the insurance code requirements to the extent that they address automotive repair dealer behavior. Most of the insurance code and the regulations that have been adopted by the California Department of Insurance pertain to behaviors and actions of their regulated community, third-party payers or insurers. So keep that in mind. This is a working draft. It's not by any means the end of what we're going to see when we hopefully get to a point where we move forward with adoption of the regulations, and that process will involve a formal public comment period, and you'll hear all about that along the way. This is an attempt to get consensus or try to as best we can to build consensus on this very difficult issue. I know we might not all agree, but we're trying to get somewhere closer than we currently are with some of this. The Bureau has been for a long time been asked to intervene on these issues. That's part of the reason why we sought statutory authority to give us that authority to draft regulations, because we always, let's go to the Bureau of Automotive Repair to settle this. Sometimes there's no easy answer, especially when you don't have laws or regulations that kind of give you that authority to make a call on a particular transaction. We just give our best advice in those scenarios. So this is trying to get us much closer to having requirements that we can essentially all agree on. I know that may not be possible. As many laws and regulations are, there's you get close, but sometimes there's not complete agreement. We'll do our best to get there, though. So thank you for that opportunity to give a brief introduction to Matt's presentation. We'll let him get through his entire presentation. It's not a lengthy presentation. Hopefully we can do that without interruption, and then we'll open it up for anyone who wants to speak on this issue. Comments, questions, concerns, we're all ears. We want to get it all out on the table today. I also don't think this is going to be it will be the first. It won't be the last of our workshop opportunities. Again, we're trying to get the best product we can going forward to present to the Office of Administrative Law, is the agency that ultimately is the place where all regulations get filed and reviewed for adoption. Matt, welcome. Sorry to take away a little bit from thought I'd give you a chance to just recover between the two meetings. We only got about 10 to 15 minute break, and people were kind of wolfing down some lunch or snacks. And if you're still doing, that's fine by me. Just share. All right. Thank you, Matt.
Thanks, Pat. I am Matthew Gibson. I'm a program manager in BAR's executive office, and I'm here to discuss the proposed storage and towing fee regulations. The proposed regulations are drafted in accordance with the authorization provided by Assembly Bill 1263, which authorizes the BAR to clarify existing statutes that govern storage and towing fees. Our PowerPoint today is 5 slides, and we'll cover the concepts that the Bureau intends to include in the proposed storage and towing fees for automotive repair dealer regulations. The proposed text is a rough draft, which is intended to solicit input. Recognize there will be changes Based on our discussion today, as well as discussions at BAR and DCA, we do also anticipate that this will not be the last workshop on this proposed regulation package. Zach, can I get the next slide? All right, so the purpose for the proposed regulations is to clarify BAR's authority to address storage fee issues as provided for by Assembly Bill 1263. It's to codify BAR's guidance to the automotive repair industry regarding storage fees and bring together existing laws governing storage fees from the Business Professions Code, Civil Code, and Vehicle Code under one unified regulation. Next slide. Proposed regulations will clarify what an ARD must do to charge storage fees after completion of repairs. It'll clarify that storage fees can be assessed prior to any authorized repairs when receiving a vehicle for storage. It'll clarify that no storage fees can be assessed while a vehicle is undergoing repairs. And it will clarify access to a stored vehicle and the requirement to accept multiple payment methods as specified in Vehicle Code Section 22651.07. Next slide. Proposed regulations will require storage fees resulting from an accident or theft recovery be charged in accordance with Vehicle Code Section 22524.5. It will require an itemized invoice of storage fees when they are charged. It will require posting of daily storage rates. It will require additional storage fee notifications when providing a tear down estimate. Additionally, it will create a process for BAR to obtain daily storage rates from the industry and provide that data on its website. Next slide. As far as towing fees, the proposed regulations will require any towing fees resulting from an accident or theft recovery to be charged in accordance with Vehicle Code Section 22524.5. It will require an itemized invoice of towing fees when charged, and will require that for ARDs providing towing, they will have to post the towing and storage fee access notice that is actually recorded in 22651.07. That's the last slide, Zach. Or you can go to the last slide. One other thing I want to say real quick, in the interest of expediency, I feel like it's going to help our conversations later as we take questions. Business Professions Code Section 9880.1F clearly defines a customer as the person presenting a motor vehicle for repair and authorizing the repairs to that motor vehicle. Customer shall not mean the ARD providing the repair services or an insurer involved in a claim that includes the motor vehicle being repaired, or an employee or agent or a person acting on behalf of the dealer or the insurer. So in other words, an insurance company is explicitly excluded from it being the customer in an automotive repair transaction. I would be happy to take any questions whenever you're ready to.
All right. That was intended to be a very high level presentation, very quick, as you've seen. And thank you, Matt, for doing that. And thank you, because I had asked you to point that out with respect to that 9880.1F provision to get that reminder out there. Posting of towage and storage fees access notice. Where's that vehicle code section? What?
22651.07.
078. All right, I'm going to open it up for comments and questions from, now, a lot of the people sitting up on the dais right now, just members of the public, but they were sitting here earlier for the Bar Advisory Group meeting, and they are Bar Advisory Group members, so that's why they've come back to their original seats. I'll start with some of those individuals, but we'll reach out into the room. And we'll also open it up for comments from individuals attending virtually. So we'll try to do that in that order. So, Jack Molodonov. And please present, since some of the individuals listening in might not know your organization, please, if you have an organization or a shop or anything, please let us know who you are with.
Yeah, thank you. Jack Molodonov on behalf of the California Auto Body Association. Thanks for the presentation, Matt. I noticed that I didn't see the actual text.
Oh.
Is that up there? I think it'd be easier because that's what I focused on, not necessarily the presentation. Yeah, well, Yeah, because the language, the devil's in the details, as we.
No, we have, not
Exactly.
paper. We have-
Oh,
Yeah,
you
that
can,
can
yeah,
pull up.
yeah. Let's
on the
pull it.
website.
Can we pull it up? Because so what we did on behalf of the, so we sent out this the draft regulations, and we received input. So what I have here, what I'd like to go through, if it's okay, some of the comments, input, suggestions. So I'll try to take them in order here, but let's just start off with probably one of the most controversial provisions is on the second page, which is actually
It's
3351.81C.
Right.
Which says an ARD performing collision repair shall report to the Bureau on an annual basis when renewing the registration under penalty of perjury, their daily storage rate for registration renewal period. So that one I have several comments on. First of all, I guess I have to start off with under penalty of perjury. I haven't seen that. Obviously, it's on the application when you signed it, but I haven't seen that really in a section here. It just struck me as now we're going to criminalize this if you don't actually submit your rates. I thought that was more of an overkill. I didn't know what the basis for that was. That just jumped out at me pretty strong.
You want me to?
Well,
I
do you
can
want me to?
explain
You
how
want me to
that-
go through the comments first, or how do you want me to go through this? Because I do have a lot here I want to go
Well,
through.
We should go one section at a time or subdivision.
One comment at a time.
Yeah.
Okay.
So if you want to
If you
talk
have,
about this,
if you have a response, yeah.
I do on the related to the penalty of perjury, but more specifically, this section, quite frankly, should probably be within 3351.2, our ARD requirements. The way we wrote this, or when we were drafting it, it intended that it would be included as part of the renewal process, as written in here. As part of the renewal process, the expectation would be that that information would be given under penalty of perjury. That's why it was drafted that way. But
Right.
so that's the explanation. But quite honestly, whether this stays in this section, I don't know that it will. But
All right.
that's
Well,
the answer to that.
okay. Well, storage rates in the vehicle code section where this derives from doesn't distinguish between auto body shops and mechanical shops, and some of the comments we got back is why are you discriminating against particular auto body shops rather than, why aren't we including all the automotive repair shops? Because you could have a strip center where you have a body shop and you have a mechanical shop, maybe in a high rent district. They're both charging probably storage rates in that geographical area pretty high. Why are we excluding the mechanical and really just picking on the collision repair? Didn't understand, the analysis on that.
Well, I could tell you is that honestly, what it says collision repairs, what it probably actually should say is, and we will have to make this spin is, an ARD performing accident or recovery of a stolen vehicle, performing repairs as a result of an accident, recovery of a stolen vehicle, specifically because of Vehicle Code Section 22524.5C1, right? And the fact that those are that's the statute that dictates the reasonableness of daily storage charges.
Yeah, but it doesn't say body shops. I mean, it's not talking about auto body versus, because you're specifically talking about auto body versus, like I said, mechanical.
Yes, we have authority. Well, I should say the authority to the authority to determine the reasonableness of daily storage charges is specific to repairs that are performed as a result of an accident or a vehicle theft recovery. So those are the rates that we would be interested in collecting and putting forth on our website.
Yeah, it could apply to mechanical if there's a theft or whatever, right?
If there is a mechanical shop that does repairs as a result of an accident or recovery of a stolen vehicle, then
Okay.
yes, we would expect that they would get
Okay.
from them as well.
And I noticed you just have one particular rate, storage rate. I know that in fact, there are multiple types of rates. I mean, some facilities charge more for indoor versus outdoor. And you've got one rate here. That's something that needs to be addressed as well, I would think.
Agree, that's a good comment. I think quite frankly, we'd probably ask for whatever the highest of all types of rates that they would charge so that we have what would be the upper level.
And really, one of the comments that we received is that there was concern that the BAR now is going to start collecting pricing information, which normally BR does not, they don't get involved in pricing or collecting the rates. In other words, they don't, it's an open market. You can charge what you want. Here, this is, the term, camel's nose under the tent, right? You're going to start collecting storage rates. The next are going to be labor rates, and you're getting into the pricing arena. And I know that was a concern. BR is taking a big shift now, getting into pricing information and collecting that data.
We don't want to be involved in any pricing. I just, what's that? There's like this expression, right? It's like, sunlight is the best disinfectant. Like this thing is difficult for us to get a handle on as far as what is reasonable in any area. We figured this is probably the best way for us to try to get a handle on it. But yeah, we have no interest in setting rates. I mean, short of certificate of compliance fees, we don't have any interest in hourly storage rates. I'm sorry, hourly labor rates or how much people charge for certificate repairs.
One of the areas here that I know that I'm familiar with is you may not have statutory authority to do this. I know firsthand that under AB 471, that was the bill, that was the low bill that you had to, that dealt with vehicle safety inspections and it dealt with citation and training. We had, or at least in that bill, we had to amend that the section to include obtaining email addresses. And I remember specifically myself had been asking the BAR prior to this bill, hey, why don't you amend the application to include an email address? Because it's just identifying information. And I remember your DCA attorneys were adamantly, no, we don't have statutory authority. I'm looking at this and collecting this pricing information, or labor rates. I personally, I don't know what your DCA attorneys think, but I frankly don't think there's statutory authority. I think that's something your attorneys need to look at, because I don't think you can do this legally.
Ultimately, we totally defer to our brilliant and talented DCA attorneys, including our Bureau counsel and our regulation attorney. I would say, though, that I don't think we would have wrote it if we didn't think we had authority for it. I know that with the changes made to Business Professions Code Section 984.16, specifically the addition of subsection B, gave us the authority to adopt regulations as necessary specific to Vehicle Code Section 2524.5, which again carries the provisions related to the list of daily storage charges. And so ultimately we'll see what the DCA has to
You're
say.
connecting a lot of dots there.
Matt, I'm going to jump in here because I'm reading this and I think there's a word that's missing in this, which is to identify I think we have the word average.
It will ultimately probably be recorded as an average. I don't know that we ever put it actually in the text, but maybe we should.
Okay.
Does BAR have any intent to publish this amount that you collect, the public?
But publish in that it would be available through like some sort of a tool, where you could look at an area and determine what would be the average amount for storage. But it wouldn't. We were specifically trying to keep it so that the information that's provided on a shop-by-shop basis would not be made public.
And what is a locale?
That is a great question.
Locale.
The location.
No, I understand that, but what is the location?
The definition.
Because I'm just imagining an AR. Is it the Inland Empire? Is it Southern California? That I'm just wondering how do you determine that? Because there's a lot of areas in the state that vary substantially. That there could be different labor rates or like different costs of real estate, dramatic swings, just a few miles if you move in one direction versus another. And I think that,
and that's the concern that we have, and the ability or the impossibility of reaching agreement on that definition. What we were hoping to do is to collect this information and then design a process by which you could do, anyone in this room could do a search based on what they feel by zip code, by city, within 5 miles of the shop that they're concerned about, 10 miles of the shop they're concerned about, and so on. and hopefully grown adults in this room can agree that's reasonable or not reasonable. I don't know that we're going to reach an agreement on what locale is and and reasonable.
Well, so I totally respect that, and I'm not trying to throw in unnecessary.
No, those are good
like,
comments.
but the whether a charge is reasonable is on what the locale is. So the in part, so the if it's zip code that so if it's if it is the case that it's locale can mean multiple different things, and if the amount is within a certain band between, like within any of those locations, of its zip code, census tract, I don't know what you want it, or the municipality or whatever, and it's within a 20% band of that amount, then presumptively this is reasonable. I think providing some depth, providing some clarity on what it means, and if an ARD, like locale, if an AR, because businesses just want some certainty that what they're charging is legal. And if this amount's being published and its locale means multiple different things, you don't want to be, as a business, like, okay, well, I'm reasonable under one of these, standards, but not two other standards or one of the other standards, because the broader index includes so I guess what I'm saying is that you could drill it a little bit, you can provide a little bit more specificity in the regs to provide more clarity for an ARD to determine whether the charge that they're imposing is reasonable.
And the Department of Insurance has worked on this, and they've, with regard to labor rate surveys, so they've spent, I know, a lot of time on that.
We've heard that.
Okay.
They had some thoughts.
Yes, they did.
Let me move forward on the next issue. I just jump up to B about the sign. So there's a new requirement. It says the ARD who charges storage fee shall display their current daily storage rate in a place where the storage rate is visible, legible, adjacent to the counter where customers are served. So, my first reaction to that is, what if they don't? Is this going to be like a Bennett versus Hayes where you don't have a sign? That means you can't charge storage?
No, it means that they'd be in violation of that section,
Well, what's the penalty for that?
that they would be.
Citation? Are you going to,
I guess-
or is your representative going to say, you know what, you don't have a sign up, you can't charge storage?
Well, I mean, the ability to have a facility to charge storage actually enshrined in the state's constitution.
I would agree with you there.
So,
That's why I'm saying,
sort of
I don't know if you can take away, that's why when I see this, I think, what's the penalty? You're not in compliance. What does that mean? What is the BAR representative is there saying, you don't have a sign? They're looking at a complaint. The shop is charging X amount for storage. Are they going to say Bennett versus Hayes? It's not enforceable. You can't charge storage.
I mean, I can't speak to what our field reps will do in the future. I
Okay.
appreciate the comment.
Okay, you got the comment. Let me move
Yeah, it
on.
would be my hope that that would not be the direction we take, the path we take as an organization. It would be more of what you talked about, obviously talking to the shop and reminding them of this provision, and failure to comply could lead down potential paths of a citation perhaps, or something along those.
Let me just jump to D, which talks about the ARD charging storage fees for the vehicle shall permit the customer, the bureau, and the customer's third-party payer access to the vehicle for inspection in accordance with Vehicle Code Section 22-651.07. That 22-651.7 does not provide for access for that's not accurate, I guess what I'm saying. And I don't know, maybe the customer does not want their insurer to go in and get, go to their car and go through personal belongings or, their computer or whatever. I don't know why. I guess what I'm saying is that that vehicle code does not provide for the third party payer to have access to the vehicle, as far as I know.
Yeah, the wording out of subsection C, the vehicle owner, his or her agent, or a licensed or.
Yeah, it doesn't say insurer. I mean, it's not talking about an insurer. It's, anyway, I think take a look at that because I don't think that's accurate. 3351.81D, I'm still in D. You know, I read I'm reading that section about how the vehicle shall be stored at the ARD's primary location, business address, registered with BAR. If the vehicle is stored at the location other than the ARD's primary business, the customer shall be notified of the storage location. You know, I started looking at that. I thought, this is kind of like sublets. You know, the language with sublets, right? You know, you need to provide information to the customer that you're going to sublet, you know, to the vehicle, but you don't need to provide them a location unless the customer requests. I don't know why we, you know, maybe a thought is to kind of mirror that language. A suggestion.
You're talking like about 3353.
Yeah, I mean, let it be consistent because it's not consistent here. Something to look at as well. And with regard to D3, if you scroll up a little bit here, Zach, it talks about how the ARD shall not charge the customer for moving the vehicle between locations. You can't scroll up. Scroll up, yeah. Yeah, there we go. See where it says the ARD shall not, what's the problem if the customer authorizes, it says, I want the car moved over there, because, you know, for example, the facility may not have, the customer wants to have their car stored in an enclosed facility, and the shop says, hey, it's 5 miles away, but I got to charge you, you know, to do it. They can't charge for it.
Good comment. Those are words we left off.
I think the customer should be able to authorize it.
Authorization is key.
Okay,
Good comment.
okay, good. Forward to 3351.81E, which is right below there. You cite the vehicle code section there, 22651.07. I don't think, again, I don't think that's accurate. I think that section refers to cash and insures check, and here you've included you know, you're just saying check. It sounds like you know, now you've changed a statute where the customer can pay by a personal check, and that's not the intent of that statute. I think there. Go ahead.
Obviously, it's a good comment, and actually not in our intent.
Okay.
It,
All right.
It's a third-party pay or check.
Okay. Okay. Good. I just wanted to make sure that you had that. Let me jump to 3351.82B, which is on the next page. And just a comment there is that it says to charge storage fees incurred, it says after completion of repairs, the ARD shall. When I saw completion of repairs, there's some services that are just performance services, just labor, like diagnostic. And I saw that and I thought, are we limiting ourselves only? So it just didn't seem to me the language could be clarified a little bit. Shouldn't it say something like performance services or completion of repairs? Something to think about.
I should just comment, and that's accurate. I mean, a repair isn't just placing parts or.
Right,
it is also-
right. It's labor. It could be diagnostic or, yeah.
Be a tear down.
It,
Tear
yeah,
down itself
exactly,
is a specific job.
exactly. Section D, which is right there, upon completion, let's see, when obtained, let's see, D was, yeah, upon completion of authorized repairs, an ARD shall not without customer authorization dismantle, disengage, remove, or strip from the vehicle any parts used to complete the repairs. I do know that's in section 3068. I just, I may have to look at that carefully. I thought that applied to legal owners, not necessarily to the shops, but I'd have to take another look at it.
It is in subsection, you know, so 3368A, and obviously we'll defer to our brilliant and talented CA attorneys. I would say though that section refers to the registered owner. This has to do with when the lien arises in the transaction and what the responsibilities of the shop are. So
Yeah,
I
that
assume it's
section
registered
limit,
owner.
yeah. It does say that language, but like I said, it applies to legal owners, not necessarily. Now we're sort of shifting it to apply different elsewhere. So take a look at that again. Let me jump to E, which is for, let's see, when obtaining authorization to perform a tear down. So when you obtain authorization to perform a tear down as defined in section 3352, the ARD shall inform the customer of the following. And that says number one, you need to move up, Zach. Sorry. So everyone can follow if they're not following. Yeah, that's section E. And it says you got to, now you got to notify the customer the number of days after receipt of the itemized repair estimate following completion of the tear down that the customer has to authorize repairs or remove the vehicle prior to storage fees accruing and the daily storage rate. So I know under current law, it's basically a best practice. You don't have to you don't have to provide this information to the customer, right? I mean,
Right now, under our current, that is correct.
okay. So now you're saying you have to provide the number of days after receipt of the itemized repair estimate. What if you, I guess I'm going back to, what if you don't? What if you don't do this? Does that mean they lose their constitutional rights or mechanical liens rights? I mean, what does this really mean, again, if you don't do it?
They would be in violation of this section.
A citation, or is that mean they can't then charge for storage again?
No, it doesn't say that they wouldn't charge for storage.
Well, I don't know. That's
It
what
has to do with disclosure requirements. I mean, and the idea that trying to
I'm
get certain
looking at the
information.
penalty. Yeah.
Penalty?
Well, yeah.
They'd be in violation of this section.
And again, I'm going back, citation, the consequences, Bennett versus Hayes, does it mean it's not enforceable? I just want,
I mean, we could, issue a citation to your situation.
Okay.
We would initially, but it's possible.
okay, let me jump quickly to F, right below there. So if an ARD tows and repairs a vehicle, I guess I was a little confused with that section because isn't that if an ARD tows and I mean, is performing, is that, it's not clear. What are you trying to say here? Because, most ARDs they're not in the tow business. They may reimburse, but they don't pay for tow. And I was a little confused by that. You're saying they're performing a tow service or not performing a tow service?
Yeah, good catch. Comment. It is supposed to be that if an ARD provides the tow.
Okay.
They are the tow company.
Okay,
as
we
well
can
as the-
clarify that. Okay, and that's the same if you scroll down a little bit for 3351.9 and A, right? That's a little confusing as well, as it talks about when an ARD charges fees for towing. I think the intent there is providing,
Actually, no,
providing
that's
towing
not-
service?
That's not the case for those sections, no.
Towing, what is the case there?
It would be that, so when an ARD charges fees, are you at 33? You're gonna have to scroll down a little bit more, Jeff.
Yeah,
51.9.
yeah, A,
When an ARD charges fees, so this is specific to a situation where an ARD is charging towing fees or storage fees or both. There are no repairs being performed. This is a non-repair transaction, straight storage. Then it gives clarification about the storage fees that could be assessed in that situation.
So
and
when you
how they
say
differ from repair.
are you saying charging fees, they're getting reimbursed for a vehicle that was towed in? Or are you saying that they are charging, they're performing the tow and charging for the tow?
No, they don't have to be the one who performed the tow.
Okay, so this is like a reimbursement. In other words, they can reimburse the tow truck, if they want to get reimbursed for a tow truck service. Is that what you're trying to say here?
Well, in that, so when an ARD charges storage fees for the towing, storage, or both of a vehicle as a result of an accident or a vehicle theft recovery, where no repairs are performed, they shall do so in accordance with 22524.5.
Okay. I just thought maybe that needs a little clarification. Take another look at that.
I appreciate the comment.
Let me.
So that would, I just check with Matt as well. That was to consider a tow they've done, tow charge that they are then passing off. They've accepted a tow. They haven't necessarily performed the tow, right?
In this situation, it would be whether they did the tow themselves or if they accepted a vehicle.
Either way.
Either
Yeah.
way.
Okay.
Yeah.
But if you follow that in the logic, isn't this where this section talks about in section 1, the charges are capped based on the California Highway Patrol rates? Right? That's inconsistent.
They're not acting as a repair facility at that point. I think is what we were including.
Yeah, that's just a confusing there for me at least.
Okay.
Let me just jump. I forgot. Let me jump to the first page again. I missed a comment there. I apologize.
No problem.
It's 3351.81 on the bottom. Oh yeah, it says there, when an automotive repair dealer charges storage fees, an itemized invoice for the storage services must be provided to the customer. Okay, let me ask you this. So if the shop lists storage, $1,500, are they in compliance?
I would think they would not be in compliance.
Okay, so I think you're going to need, as Anthony mentioned, some clarity here. What you're asking for is the number of days, storage rate per day. Is that what you're looking for?
I would say at the minimum, I would be thinking we probably want to break down the number of days storages.
I think you need to say that. I think you need to be clear because
Provision?
it's
So-
3351.81
On A, it's
A.
on page
Yeah,
one.
because to me, the way I read this, if they list storage, $1,500, that satisfies this. Just because you itemized it, right?
Yeah,
he went
in a
back.
sense, I see, but no, that's, thank you for the comment. Yeah.
Okay, okay. And then let me just kind of go through a couple other things and I'll finish and then let someone else speak. But I know that in the section that provided authorization, which was 9884.18 that Pat had mentioned earlier, you have the authority to reference the vehicle code section, the civil code section, and fair claim settlement practices. I didn't see any reference to settlement practices, claim settlement practices. I've seen it in the guidance, but I haven't seen it here. And I think it's important, and I think our good friends at PIF would also agree with, that you need to have at least some reference to some of the sections that deal with where the insurers must pay for reasonable towing and storage charges, which is under the vehicle code section and in the fair claims settlement section. And then also the area where it talks about where the insurers have a right to inspect within 6 business days. I think there needs to be some reference to this somewhere in the regulations. I think by not referencing, I mean, that's the intent of the statute, right? It specifically calls that out and you haven't even referenced it here. So I think it's more transparency. So if someone's going through these regulations, they can see, hey, you're defining third-party payer. They have responsibilities in this as well. So I
Right.
think that's important.
We don't regulate those third-party payers, so it's tough to draft a regulation that puts requirements or just it won't put requirements on insurers because we don't regulate them.
Correct.
We don't have authority to regulate them.
Correct.
So
You can
I guess you
reference
could
it.
do a reference of some sort. I don't know how to do that. We'll have to think about that. That wouldn't be a requirement
Well,
of
we
the
have to-
ARD, but at least put them on notice of the things that another regulated entity and laws that they are subject to. I don't know how to do that.
Let-
Let me give you a suggestion.
Oh,
then,
great.
okay?
Hold on.
Yeah, I'll give you a suggestion. So under 3351.81, you stop at F, I would add a G. Okay, and I would just say towing and storage charges fees are subject to vehicle code sections 22.5, 24.5, and fair claims settlement practices, and I'd list those sections 2690. That's all I would do.
Okay.
I just say they're subject to, right? You're making the reference. That's my suggestion. Have your legal counsel look at it. And yeah. And finally, my last comment, and I'll shut up. You have dealing with some tear down regulations right now. I know they were discussed earlier. Hollywood discussed them. They define third-party payer. They're talking about tear downs, defining. You're doing the same thing here. My suggestion, or at least to look at, is combining the two. And let me just finish. The reason why you're going to have 2 sets of regulations, and both regulations are going to require the industry to change their software programs, and that's expensive to do. We keep on changing. So, and again, they're very related. I think the preference would be, and cheaper and easier, is if you can do one combine them so they can, they have to change their software programs one time rather than 2 times. That's my point there, right? It's going to be smoother and easier and cheaper for the industry.
I thought you were
It's
saying
just-
we should have combine the definition of third-party payer in both regulation packages. Of course, that already is, but
I'm talking about combining them,
I
yeah,
understand.
so to make it, more efficient for the industry. Because you're dealing, I mean, there is overlap here. Anyway, that's my suggestion. Thank you very much for your presentation and your patience with me.
No, thank you.
Thank you
Very
for the
good comments. Appreciate it, Jack. I'm still thinking about that G that you've suggested. I don't want to send a mixed message to the automotive repair dealers that they now somehow have to, they're now being held to these other provisions because those provisions don't apply to them. They should be aware of them. I'm not disagreeing with that. Don't want to send a message in our regulation that
What if-
somehow they're being held to these. This is of the insurance industry and those regulations that you're mentioning. We'll think about it. We'll talk to our legal counsel about if there's a creative way to do that. Other comments, questions, comments? Can I go this direction too? I don't want to look, yes,
Thank you.
Yeah.
Thank you.
one of our bar advisory group members,
Fly in the milk over here.
Saren Taylor.
Saren Taylor with the Personal Insurance Federation. And greatly appreciate the work of BAR and the staff, and also appreciate all the other stakeholders here too. This has obviously been a lot of work on this issue over the years between a lot of people. So yeah, obviously there are a couple of things. And one, I think I've sort of heard it in the conversation here, but just I thought it was helpful to clarify that you're thinking about the vehicle code 22524.5. You're viewing that as this applies to any and all automotive repair dealers storing vehicles and charging storage rates, regardless of whether the ARD tows the vehicle or not. Thought that's what Jack was sort of getting at in that other section. Talking to Matthew.
That's right. And was that a question?
Yeah, just
Okay,
sort of,
so-
we wanted to just make sure that we understand that this applies to everyone regardless of whether they towed the vehicle.
Yes.
Yes, okay.
As far as the reasonableness of daily storage charges for repairs that were a result of an accident or a vehicle theft recovery. Yes.
Sharon, there seems to be some folks in the room who can't hear you. Coming
Okay.
in on the web,
Okay,
but mic on?
the mic, I believe, is on. I don't-
Okay.
I guess I got to get right up on it. Yeah.
You're good.
I got to try to do that
I'm
as
hearing
I
you fine, but I got some feedback that back in the room couldn't
As
hear
I
you. Okay.
look at my notes here. But, and so I'll kind of approach it, I guess, the same way that Mr. Molodanoff did and try to just run through the different sections. Under 3351.8.1. A, we thought adding the words actually written itemized invoice would be helpful, as well as not only having that go to the customer, but any third-party payer as well. So that was a suggestion that was there. Under C in that same section, did have a question, and I'm guessing, I think I'm going to know what the answer is, but folks were sort of wondering if you had any sense of when the search tool would be available, like what the timeline of this process in your guys' view.
Well, these how regulations take a little bit of time.
Yeah.
It would probably need some, like almost 12 months of data in order to be able to populate the information necessary for such a tool. So a couple of years, or longer.
So a couple of years following the regulation being in
No,
place,
probably 1 year after the regulation
okay,
would be effective, and we start collecting that information.
and then the tool would then be available after that?
Yeah.
Okay. Appreciate that. Obviously, that is, and a lot of what you guys are getting at here gets back to this, legislation from 2019 that sort of got into this, space of the CHP rate, the local, the average regional rate, and then how does anyone know what that is? And so having any attempt where folks could try to understand what those are would be really helpful. Towards that, and I think a colleague down here raised some questions about having those rates published out there. And so, on the flip side, thinking about the ability for shops in a region, however defined, to be able to, look up each other's rates and potentially have some sort of collusion in trying to say, hey, let me see what everyone else is doing. And then we see this sort of rate inflation that occurs. and just being mindful, at least that bar would be looking for that. And certainly I think, insurers would be looking for that and would not anticipate. Obviously, we expect everyone's good actors and that's not what's going to happen. But we just want to sort of be mindful of that possibility as well.
Yeah.
So let's see, with that in mind, let's see what else we had here. I'd say, one of the, on section F, I guess we were curious, what scenario are you envisioning here when you talk about prior to any authorized repair?
Okay, so
Yeah.
in the scenario I would be envisioning would be a vehicle that was, well, first off, this scenario is specific. Okay, so we're talking about a situation where a vehicle is delivered to the repair facility and they have no idea who it belongs to. Perhaps they don't even want to work on it. They have taken possession of the vehicle. Lien has arisen as a result of Civil Code Section 3068.1. They are just in possession of a vehicle. They have not contracted to perform any repairs.
Okay, so I was trying to figure out, is this sort of getting at, again, the 6 day kind of obligations, or is this potentially, would there be a scenario under which an ARD could receive the vehicle, from the consumer with the insurer's knowledge and say, great, we've got it. We've got a lot of backlog over here. 5 other cars we're working on. We'll get to that in about 3 weeks. Time could be charging storage.
That would come down to the interaction between the insurance company and, well, I'm sorry, between the repair shop and the customer. And if there was an expectation on the part of the customer that the shop was going to perform repairs, they're not choosing to work. They're not wanting, they know who the car belongs to. I guess they're willing to work on it or not. I don't know in the situation you're describing, but the point is, no, that wouldn't be the situation covered in this situation. Why? That's not the situation.
I guess what we're trying to strike. Okay, I will attempt to do that. I will admit I'm famously a low talker. So I will try to do that. I think I guess what we're trying to get at is that the storage rates shouldn't really accrue until after authorized repairs are completed, right? If you're going to repair the vehicle, then the storage rates don't accrue until after it's completed, and then there's an expectation that the insurer is going to take it, or the customer is going to take action.
I agree on that too, but I also expect, I would say that if a situation where a vehicle gets delivered to a shop and they have no interest in performing repair work because they believe it's not economically viable to repair it, they're not required to repair it.
Right.
So now they're just storing it.
Yeah,
And they'd
sort
be entitled to storage.
sort of like the scenario you were talking about earlier.
Exactly.
Yeah. Okay, got it.
Can you give a scenario?
Well-
Just like it's got Sunday out.
You want to,
Scenario around. That's not gonna.
Gene, please introduce yourself just for the benefit of everyone.
Gene Lopez with Seidner's Collision Center. So a scenario might be a Tesla, and we're not authorized to repair Teslas, gets dropped off on Sunday afternoon, and we don't know who that vehicle owner is. And now we've got that car for 7 days. And on the 7th day, we've been notified who that owner is. We should be able to charge storage for those 7 days. It was in our way. We had to move it around. That's the scenario that you may be looking for, is that it's not that we don't want to fix it, but we're not authorized to fix it. We're not an authorized Audi or Porsche or Tesla repair facility. And so we can't repair it.
thank you. Actually, that's That's a great illustration. And Sharon, the question you're asking is almost, I think, keep in mind that the customer is the customer, not the insurance company. And it
Right.
seems as though your question is about when the insurance company may or may not be aware when the vehicle was delivered to the shop. It has to do with the customer and whether the customer is going to enter into a repair contract with the shop or not.
Yeah, well, I think the concern is, again, not the expectation, the concern just being that you can't just have a car knowingly sitting there collecting storage rates and just saying, we know we're gonna repair it, but we're gonna wait a month and a half to repair it, right? So it's just, that's a different, I understand there may be a lot of unique scenarios where this would apply, but just really to make sure that there's not abuses that happen and it's not interpreted in a way that it could be abused. Yeah.
Okay.
So let's see. So, I do think, oh, sorry, popping back up to E and I think Mr. Maladonov mentioned that in here that the customer in an ARD charging storage fees for a vehicle shall permit the third party payer or tow hauler to pay for towing and storage charges by a valid bank, credit card, check, bank draft. Were you saying the customer, this should not apply to the customer? Because we thought this should apply to the customer as well.
I think that, well, here's what I'll say, is that this section, so subdivision E, is derived from 22651.07 subsection E5 and also I, because there's two different sections within 22651.07 that address this issue. I will say that I think that it applies, one section is specific to the vehicle owner, which is C5, and that talks about the idea that the customer can pay cash to get the car, right? They can use a bank credit card, but even in that section, it talks about that they could pay, but it has to be an insurer's check. It can't be a personal check from the vehicle owner. And I, which is specific to insurance companies, lays out the same scenario, which is that they could, well, actually, I don't know if it said cash specifically, but the point is that it said a valid bank credit card and insurance check or bank draft.
Gotcha. Okay. Thank you. Let's see. So to skip around here, I think we had similar questions to the gentleman on the recording here around locale, how will it be determined? So shared wanting to understand that, appreciated Patrick's response that you're looking for folks to have, I guess, city, county, distance in miles, and how do we all interpret that and then have, some common understanding of what that means. So when we talk about in B, I guess in B, to charge storage fees after completion of repairs, does it contemplate how much time does a consumer have to pick up the car before the storage fees occur?
On C?
On B, under locale on page 3. So 3351.8.2B.
So upon completion of the authorized repairs, common ARD shall not, that's the one you're talking about?
Yes, sir.
Okay. Does it contemplate how long they have? So the lien arises in the transaction after completion of the repairs and notification to the customer that the work, or 15 days thereafter if they can't contact the customer. So I guess storage could accrue at any point after.
So upon whenever the customer's contacted.
That the work is done.
Let's see, under same section D, where it talks about upon completion of authorized repairs, and ARD shall not, without customer authorization, dismantle, disengage. Do you have a scenario in mind when you put that in there?
I would think that first off, this subdivision is derived from 3068A, which talks about the fact that in a repair shop, at the point that they are holding a car from a customer after the lien arises in the transaction, they can't go back to the car and start taking all their parts back off the car. And so that is the concern, would be that a car is being stored for whatever reason, the car is not being retrieved, and it's to say that a repair shop can't remove those parts. Having said that, there's other scenarios that I could envision where the shop says, let me take my parts off the car and you can have it back. And so perhaps it would be okay to allow them to do so if the customer is willing to authorize them to do so.
see. Let's get that. With regard to 3351.9, is there, and I think we've had this some version of this conversation for years, but is there any opportunity for guidance or access to CHP and local agency rates?
I don't have a really good answer for that, other than I think.
I do.
You're not gonna, can you hear me? Everybody in the back? All right, we're good. You're not gonna like the answer. So I called CHPs and spoke to their officer who's responsible for the statewide management of some towing rates. Each jurisdiction, 100 and something plus, it's not by county, for CHP,
You're popping your piece.
back, but then they can't hear me in the back.
Well, there you
But they can hear me. I talk pretty loud. There we go. Each CHP office, the sergeant sends out a request for bid from towing contractors, and they provide their, however number choose to reply, provide their towing and storage rates. CHP compiles those. They throw out the ridiculous outliers, and then they set the rate within that. And anybody, whether they provided a bid or not, who tows in response to a CHP call has to follow those tows and storage in response to a CHP call has to follow those rates in that jurisdiction. There is not a compiled statewide list by CHP. To get the CHP rates, we would have to contact each office separately. The information is public and it would be made available, but each office would have to be contacted independently at those rates.
Any contemplate, what's the workload to do that?
Guess would be as good as ours.
100 and something phone, 100 and I want to say 147 pops into my mind, but that's probably wrong because it's not a one office per county. It's multiple jurisdictions, and each one is separate.
Yeah, I mean, because, so then how does that become enforceable in the regulation?
Well, on a case-by-case basis, we can make that determination if necessary.
So you can reach out to the individual CHP
Yep.
offices.
Yes.
and-
Thanks, Bill.
Yeah, thank you.
You're more than welcome.
You're a champ.
Needed to prove I was awake.
Then just to suggest on the provision 2 under that same 3351.9, again, provide an itemized invoice for those fees to the customer, and suggest also in the third-party payers as well in there. So, thank you. For the additional discussions as this move forward, but
Thank you
appreciate
for the
everyone's
comments,
time.
Darren.
Thank you for the comment.
Yep, I'm gonna go back and forth here for a little bit. Anthony Bento.
Thank you. And I know I've already
Please,
mentioned
the
it.
association, yeah.
Oh,
please,
yeah,
just real quickly.
Anthony Bento, California New Car Dealers Association. I know I've hit on it before, and thank you, Jack, for letting me make your presentation. But I think we have to define locale, that you're gonna need to define it eventually. And defining it in the regulations makes sense to me, even if it includes multiple definitions, whether it's CHP districts, it could be a locale potentially even, or, that could be legislative districts. It could be, that it could be counties, cities, or zip codes, census tracts, whatever you think of. That makes sense from your end, but you're going to need to define it to create this search tool, to publish the information. So
I think what the beauty of it is we don't have to create it for the search tool, and that the search tool will be able, you can pick whatever you want. You pick your own adventure. Like if you want to know
Do you have a year to spend with everyone in this room defining locale?
it's not. It's
I don't know how to do that.
So
I think we were hoping not to have to do that
So
and
if
let
you-
people pick what they felt was a locale.
So you could pick whatever I
Yeah.
mean, you could, if you
Give you the option.
if you're the consumer then and you're picking the locale, you could what happens if you pick a locale that says, say the ARD is charging 150 a day.
Okay.
And you pick a locale and it says the average amount in that locale based on a zip code is 140.
Okay.
And then you pick a broader locale and it says the average is 170. And you pick, the even more granular locale and it says it's 100. So, and what is the locale in that situation that the ARD is going to be held to? What is the comparable rate that they're going to be held to?
I think that if you look at, so if there was a situation where there was a dispute in the amount of the daily storage charges, as in as a consumer, as you said, was the one that was raising the issue, they would deal with it by filing a consumer complaint. One of our representatives would look into whether the rate that was being charged by that shop was comparable to other shops in its immediate area. However, we chose to look into that and to determine if it was reasonable, make a determination and a recommendation based on our findings.
It's just, so when I hear comparable and reasonable, it just strikes me as they're very squishy words. What does comparable mean?
Well,
Does it have to equal the average?
well, if you think about it this way, think about storage fees, they can be charged for multiple ways. So I could charge inside storage or outside storage. Apparently I can charge off-site storage or shop, it could be different at my shop. And so the storage rate average of the area may be whatever it is, but it may not actually represent somebody who charges storage for inside storage. We'd have to determine if it was comparable or not comparable.
But I guess what does comparable allow some amount of variance? And what is the amount of variance that is allowed? So if I'm 120% of the applicable locale, am I comparable?
I think independent of if we come up with a definition of locale, I don't imagine we're going to address comparable. And the reason is because we are not going to set the price. And if we give you the range that is, if we are the ones who are defining what comparable is, we are literally telling everybody what to charge. I don't know how else other than, I imagine some variation is completely normal.
I mean, this regulation though is telling people what to charge. I mean, you're saying you can't charge something that's unreasonable based on the locale and based on, comparable storage rates. And so you're going to be necessary, if you're enforcing that, you're going to be making a determination that the amount is unreasonable, that the amount you're charging is improper. So I know that there's an advantage. I mean, it's easier now to not define some of these terms, and I don't know how to define these terms, but I'm very concerned that in practice, it's going to be very messy. And I'm concerned too about certain ARDs feeling like they are being singled out or that they're being treated differently because, or unfairly because there's a nebulous standard that's being enforced.
I would just say one other thing. This section obviously is derived from 22524.5 C2B. And the last sentence or last part of that does say that the reasonableness of those storage rates in that locale doesn't prevent a shop from charging more or less if otherwise.
So that's, I think and it's touching. The way that I read this reg, so you mention in 335.1.8.2a and in 335.1.9a1, there's a reference, they specifically cross-reference vehicle code 225.24.5. And I think the applicable subdivision would be C in that situation that talks about that. But that's written in or. The towing and storage fees may be based on the CHP or agency limits or regional locale limits.
Yes.
The way that this is written, it seems to imply that if the fee is resulting from a repair transaction, you are precluded from using, say, a CHP rate. And if you are the towing and store, if there's no repair transaction, you're precluded from using the locale rate because, I'm sorry, go ahead.
That's exactly right.
Is that in the statute?
Well, it is in that, we were trying to do apples to apples comparisons. The lien arises in these two different scenarios in different ways. So if you look at C2B, we're talking about storage facilities. I guess I have to look at, I don't have, I didn't, talking about repair facilities and comparing apples to apples, repair facilities that are performing repairs versus towing and storage, which is what is A, doesn't imply repair at all. That lien arises under.
So so there is an intent to only apply, in the situation where, there is a storage fee resulting from a repair transaction. You're only gonna, you believe that C2B is the only, provision that's applicable
Yes.
and not C2A.
And it's important to point out the reg says it's not that they're held to those rates, it's they shall not exceed those rates. And so we're not specifying the rate. And again, the search tool is just to give everybody to prevent what has already been indicated is happening is to remove the necessity of ARDs to have to call the 6 shops around them and say, hey, how much are you charging for storage? Because that leans towards Saren's concerns of, and ours legitimately of collusion as to of setting of the rates. Whereas if we have a searchable tool, and again, as Matt says, our highly qualified and esteemed legal counsel at the department is going to give us more guidance on this as we get to that point. But the vision is just a tool on our website that references to a non-public database, because we don't want to say Bill's Automotive in Rancho Cordova charges $200 a day storage.
Mhm.
We don't want that information out there. We want the consumers to be able, the users, the stakeholders, whether it be industry, insurance, or consumers, or us, to type in 95670, the Rancho Cordova zip code. And like we do, all of us have used search engines, I assume, on the website where it says, do you want to look within 1 mile, 5 miles, 30 miles, or 300 miles? What do you want your range to be? The user can pick the range. Obviously, 300 miles in California is not a reasonable range. And again, the squishiness that you correctly pointed out, Ann, is directly quoted from the statute. The statute uses locale. It uses similar, and it uses similar facilities, reasonable, and so forth. And so,
Well, you have I appreciate it, but you have an opportunity when you're drafting a regulation to go beyond the statutory language and provide clarity about
to
what-
clarify the statutory language, not go beyond, not
No,
make
no,
new law.
But totally, but you have an opportunity to define locale. You have an opportunity to define comparable.
And I think as Pat has said, as Matt has said, I don't know if we can define locale, because if it's within, trying to draw, you had a good example of where West Sac wouldn't be the same as, what was your example, or?
Only if I remember. No, I mean, I'm just kidding. No, I compared Oak Park to what, Midtown or something.
Right.
Now they wouldn't be,
Yeah.
they're geographically close, but the storage
Yeah.
rates wouldn't be the same. Yeah.
Right, because the real estate prices are differently. So yeah, Oak Park compared to Midtown, real estate prices, cost of doing business, everything is different. And
That's 2 miles away.
it's
Yeah.
2 miles away. So how do we define locale? But where I live in the Central Valley in Merced, it's probably going to be the same rate all the way across Merced County. Maybe a little higher in Los Banos because you're getting over to close to the Bay Area. So how do we narrow down locale? And we felt it would be easier to allow the stakeholders to define that. And then, and this is again for setting the rates, how we're going to determine and interpret it for penalty purposes, as Jack raised, and so forth. It's going to, by necessity and by the requirements that are placed upon us by government code and provisions of the VMP, we're going to have to be much more defined, much more granular, and do more research than just, the website is just a piece of information for people to use. It's not a regulatory something specific.
But it does seem that you're anticipating that the ARDs are going to use the website tool to determine whether they are in compliance.
Yes.
And so can an ARD flip through, say if you give a 1 mile, 5 mile, it sounds like you're thinking geographic
Right.
radius, for
Yeah.
the tool. So you have 1 mile, 5 mile, 10 mile, 25 mile options or whatever. in
Yeah,
the
I don't think
tool.
we'd go beyond 25.
Yeah, but
in
but
this
like,
circumstance.
so can an ARD just pick whichever one they want, and that one, if they land within again a certain band of that amount, are they okay?
If it's comparable to the other shops in the area.
I guess
But
we're just keep. It's,
I
I
got
feel
your
like
point,
it's
but I don't wanna-
circular.
But it's going to be an average. In theory, it would be an average. And so we all know with an average, if the average is, in your example earlier, 150, in all likelihood, there's 180 and 120 in there as well.
And so
And
the
so
is the 180 guy violating the law because it's not comparable?
But it might
It
be unless we
depends.
looked into it.
I feel like we're running in circles.
It
but
depends.
But I appreciate the hard work. I do think that I mean, without clarity, it's going to be a mess to enforce. Unless it's truly egregious, like you have folks that are completely, out, that like doing things that are totally outrageous. But in situations where, it's the average is, 150. And that means there's one guy that's charging 130 and one guy that's charging 180. Well, it seems like in that when you're creating that average, you're assuming that everyone is comparable, that is incorporated into the average. But anyway, I don't want to.
yeah, and we certainly appreciate all the comments that we're getting on this topic, and we'll definitely have more meetings and more discussions about it, and play it out with council. But I think this is just Bill's opinion. Let's be very clear on that, the disclaimer. I think if we had $150 average, $150 storage rate, average storage rate within a locale, and we had a shop at 350, we'd probably have a problem and be looking closely at that ARD. But if it's at
Additionally,
180, 170,
Additionally, if you say it's got to be within that 20% of that $150 average, guess what? Everybody's going 20% higher.
Yeah.
Okay, so I mean,
I
it's really,
get.
Yeah, but Anthony, pardon my interruption. Gene Lopez again from Siders Collision Center. Bill, if I am at capacity and I don't want to keep another car another day, and the only way for me to get the bill payer to remove that car is to say, our average is 150. You're going to have to move this car. I'm charging you 350 a day because they won't move it otherwise.
yeah, we're not going to allow for that in the regulations. We're not going to allow anything we do, however we solve this, we're not going to allow for floating rates for you to change the rates on a daily basis
Well-
based on the circumstance. That's why you have to
But
post them.
Matt said I could have an indoor and an outdoor rate.
You,
Because we want, yeah,
Matt
exactly.
did say that.
So
But he didn't do the disclaimer that I did, that this is Matt's opinion.
But that's what we're up against though, Bill, and you
Yeah,
realize
I
that,
realize
right?
you're
I-
that.
We
but-
can't have a car wait for a third party to inspect that vehicle for 15 days.
I'm sorry, what was that again?
So often
They can't have a wait for 15 days for an inspection by a third-party payer.
You're right, and you
Third
shouldn't have to because the insurance company is not the customer.
but the,
If you wait 15 days for the insurance company, it's that you're doing that.
no, the vehicle can't be removed until that third party has approved the total loss.
So you're saying a vehicle you didn't enter into a repair transaction on is just sitting on your lot?
Wait a second. No. So vehicle comes in. We write an estimate on it. It exceeds the actual cash value of that vehicle.
It's not economically feasible to repair.
Correct. And in order to have that vehicle removed from our party, we need a third party authorization. We need that insurer to say, yep, it exceeds the actual cash value and the vehicle can be released.
No, he's right. It's salvage pool. And you
Well,
have to have
I-
authorization.
I got the reference. It's that
Yep.
I want to go this.
I don't know that that's
this
the
road.
problem we're attempting to address here.
No, that is the problem.
No,
That's how this whole thing came up.
but you're entitled to charge storage from the day you make complete the contracted repairs.
Yeah.
And can communicate to whoever, whatever parties you're dealing with. We're starting charging today. Here's our estimate after teardown. We determined the vehicle is not economically feasible to repair. Only the insurer can classify it as a total loss. However, we have completed our contractual obligation and storage will begin to accrue today at our posted rate of $200 a day. And then, and this is the part where I said, whatever time it takes to resolve that is not part of this regulation. Because all we're here to resolve is what are reasonable storage rates. And again, it can't be a floating rate. Can't be, well, we're going to charge more because we're out of room today.
Well, then we go back to locale that Anthony is concerned about. If my locale in West Covina, California is at capacity, and typically it is, but you're telling me I can't have a high-end rate of $275 because it doesn't meet the locale rate.
No, I'm telling you that you have to have an established rate that doesn't vary and fluctuate.
Okay.
That you're,
Oh,
because
so-
you're saying your normal rate's 150.
No,
but to
no.
get the car removed, no, that
No,
is,
no, you're saying it's 150. We're determining that because of that locale, because of that location in West Covina, California, that is typically at capacity, and we don't want to store a vehicle longer than needed, our storage fee is going to be $275.
I misunderstood because
And
I,
you,
no,
and I did,
let me fin- let
I
me-
did say something.
let me finish, Gene,
yeah.
because I want to clarify my misunderstanding, because I misunderstood that you were saying that your normal rate is X,
I did.
and that because you don't want to store the vehicle, you're going to raise the rate,
I did.
which is the part that I said,
Right.
no.
I did say that. You're correct.
Okay,
But-
all right.
But I want to get
But
back to
if
this
if
locale.
275 works in West Covina and that's similar to other rates, then it's a reasonable rate.
See, that's the problem, Bill, is because I want to charge 275 because that's my property value. I am at capacity. Now, the body shop down the street on Workman Avenue is not at capacity and they only want to charge $100, right? Because they can afford to keep that vehicle on their property for 10 or 15 days.
So you're saying capacity should also be brought into
I
what's used to calculate the rate.
I'm not saying that should be brought in. I'm saying that locale should be not in the equation because my locale is going to be different than the body shop a half a mile away on the same street.
Well, we have to use locale because it's a statute.
That's how it reads.
But certainly.
Sorry, no,
I do want to say great discussion and great back and forth. And thankfully these are recorded because we will go back and consider
Sure,
every
yeah.
comment that's made.
Yeah.
Saren, go ahead.
No, I just want to add, I think, to point that there's discussion about the averages. So to the extent some people are higher, some people are lower, that's going to fit into this idea that you're talking about an average. And you know, I certainly understand the discussion here around, you don't want regulator to come in and set a price, but then what is it? If it's not set, then what is okay? I would just offer that, you know, certainly in healthcare and health insurance for a long time, there's the idea of usual, customary, and reasonable for a geographic area. It's an established practice for decades, and maybe there's a model in there that can work.
Okay.
I'm
Thank you.
gonna run away.
Thank you.
Let's go.
I am too.
Thanks, team.
Anthony,
I just have one
and then
follow-up.
I'm gonna try to get some additional voices heard. Okay, yep.
Just one follow-up question. Are you intending on this website to update it on an annual basis as well?
I would imagine it's actually be updated on a monthly basis
Okay, so as you get more information,
Yeah.
the amounts will change. Okay,
as shops are renewing.
Because ARDs are renewing every day.
makes sense. Thank you.
Additional comments up here. Yes, Dave Kusa.
Hi, Matt. So Dave Kusa, Automotive Service Council, California, also owner of Auto Trend Auto Repair, mechanical repair. So storage, we don't do storage. I can't remember the
you
last time I
could.
charged storage. I often threaten to charge storage to get people to come get their car. So if I don't actually charge storage, do I have to have the signs and the disclosures and disclaimers and so on and so forth?
No.
Okay. Yeah, 'cause
Well,
I
no,
mean,
that's not envisioned by these regulations.
okay, good. Yeah, because I mean, the clearly more towards the collision side of the industry, right? And yeah, I know, and we do get some insurance tows, but again, I mean, I haven't charged storage in 20 years, so I just tell them it's $400 a day to come get their car, and they do, like that day.
Some of the requirements are specific to the scenarios we talked about within Vehicle Code Section 22524.5, but it applies to any shop that would charge for storage.
Got it. Okay.
So,
It's yes, you charge it. Got it. Okay. And then the towing, posting of towing. So again, don't have a tow truck. Generally, customer pay or insurance pay or AAA tow. Occasionally, I do have one company we have an account with that will write a check to them. I just pass it along. I don't know what that fee is going to be until the car is actually towed in. So how do I post that? Or do I have to post that?
you don't have to post
Okay.
that. As a matter of fact, there's a specific carve out in 22651.07 that says that you don't.
Excellent. Thank you.
Bud Rice.
I'll go fast, I promise, and I want to get Walter back up here again if we can, so I'll go quick. So what Bill had said a minute ago was with the CHP guys. And to me, these are two separate things. When you're talking about the CHP guys, they're gonna see somebody stranded on the road. They're gonna call somebody that's on their list who has agreed at a specific charge to come get that car and take it to a facility. They've agreed they want to be on the list. So they've raised their hand up and said, oh, you've determined that this is what I can charge. I can live with that. And they've agreed to do that. That's that. This is completely different than that. This is not shops getting able to charge what they want to charge for something. And this is a controlling the market, the free marketplace for what somebody might be willing to charge. When we were talking a minute ago about, well, I want to charge $275 for storage, and you're going to say, well, no, 180 is the top dog, and if you're above that, we're going to come check on you. I don't know how we're getting away from a meeting of the minds. If a customer calls me up and says, hey, bud, listen, I thought I would have my car tuned up. I need to leave it there for a week. And I say, okay, well, I'll charge you $110 a day after we get done with it, and you could leave it here for a week while you're on vacation. Cool. A meeting of the minds. He's agreeable to that. Another guy calls up and says, hey, listen, I want to leave my car there for a week. And you go, well, I need to charge you $200. That's too high. Okay, well, call the next guy. So there's no meeting of the minds, and that's if he gets to go choose something else. I should get to choose what I want from the market to be. He should get to choose whether or not he wants to buy that or not.
But the vehicle code in relation to a vehicle that has been towed and stored as a result of a collision or theft recovery does not allow for that varied rate. The vehicle code already has controlled the marketplace and said it shall be A or B. It shall be one or two. It shall be, if it's not repaired, it shall be similar to it shall not exceed CHP or local law enforcement rates. And if it is repaired, then it can fall under B, which is similar to a rate that is comparable to similar facilities within the same locale. It's already, those rates have already been set.
Okay, I got it. Thank you.
But
Yeah.
good point about,
Thank you.
that's why
Yes,
we're trying
no.
to get disclosure.
Yeah,
Would be
we're trying, and ideally, and I just want to say this for Jack, Anthony, and really everybody, our hope would be that the facility would have a really good idea on what their space costs them, or what the value of that space is on a per square foot, per bay basis, based upon the revenue it generates, their cost, their overhead, and everything. All the business factors, take those into consideration and calculate their rate based upon that, and not what they found on our website when they used a search tool.
Yeah, but if they're out of whack, you're going to chase them.
If it's not comparable.
Yeah,
Well,
yeah, if they want to charge
Well,
more,
we're,
then you
we're,
want to.
we're
they're
likely going to
change
go and say, to the example I gave with Anthony, well, the average in this area is 150. Why are you at 350? What are we not seeing? And maybe they have a perfectly good reason for that.
You say the vehicle code even allows for that
Yeah.
variance,
higher or
Yes.
lower, if otherwise reasonable, yes.
if otherwise reasonable.
Yep.
So-
Additional comments, questions? We've got some in the audience here. I saw the lady in the second or third to back row. Please come forward and introduce yourself. I'll get to you, Pete, and I'll get to you.
Oh,
I just saw that hand first.
please come.
Oh, that, I,
I didn't know you were. Yeah.
I saw her.
Someone else.
I went in the order I saw. She got her hand up first. Welcome.
Hi, thank you. My name is Erica Williams. I'm here from CSA Insurance Company, and I'd
Okay.
like to kind of give the insurance company perspective.
Sure.
Thank you for putting this on today and for the proposed regulations. We think it's very helpful, but I just kind of want to give our comments and some feedback. I'll try not to be repetitive.
And if you have them in writing too, if you want to submit them
Yeah.
at either today or later, you can send them to us. as
Okay,
well. Yeah.
yes, I can do that.
And that goes for anyone here.
If you let us know the section, they'll scroll up on the screen.
Okay, so I'll just go to the first page and kind of run through it like we've been doing. For section 3351.8.1A, I just want to echo an earlier comment that the word written should be in there for itemized invoice, because that is a problem that we've been seeing in the billing, that they come through verbally. And even though it's detailed as an itemized invoice would be verbally, that's hard and inconsistent, especially when we change hands with adjusters. So I think that is a very important thing to add. So I just wanted to echo that. And then going to section C, on this one, I do like the comments that it will be updated monthly once it is available. However, the locale issue, I think, overlaps with our CHP issue, because if you're not going to define locale, that's going to make it very difficult for insurance companies who are unfamiliar with certain shops, as well as shops when billing insurance companies that they don't have a pre-existing relationship with, to agree on the rates. You're going to have inconsistencies. We've already been seeing this on a daily basis in our company. And with the CHP rates, you can get this information through a request with the Freedom of Information Act. And that is something that the DAs that I recently spoke with have commented is pretty much the only reliable way of getting that information. But if everybody is doing that and not the BAR, that's going to inundate the offices. Potentially, you could only do one if it came from the BAR, and then you could publish it on this website tool as well. And that would be handy for everyone, I think, involved. However, then you would have a reference point for locality based on the CHP grid that you would be able to provide in that same, and then the insurance company or the shops looking at rates can do it using the website tool by plugging in their own numbers, radius, miles. That might be an easier way if you have them side by side and available for everyone to look at on this website tool, since you're creating it anyway. Another comment that I wanted to make on that is with the CHP rates and the public rates, there's wide variance across the board. If you look at San Francisco, you're seeing rates upwards as $400 a day. But you go to Antioch, which is not even 30, 40 miles away, you're under $100 a day. So that's very close in geography. You know, with traffic, it can be 3 hours. Without traffic, it can be 20 minutes. You know, so it's not really something that's reliable if it's vague. But if you reference the excessive rates in comparison to the public rates, that might be a helpful tool to put a cap on it at the very least. So say a percentage or a multiplier or a dollar amount. It cannot be in excess of public rates by 4 times or 3 times, just so it's clear. Even if you're not specific to the radius or specific to the dollar amount, if you reference it by proportion, that might be very helpful, at least at this early stage, and then we can see how that plays out. But just a suggestion to consider when drafting these regulations. And then I wanted to also clarify down at 3351.8.2A And then also with the next section, 3351.9, the difference between repairs performed and not performed. I think that is going to be a point of dispute as these are worded, because it's vague and unclear as to what that means, performed, and what repairs are included, because you can completely repair a car start to finish, there's no dispute there. But what in the event of a total loss where a diagnostic's performed but no tear down? There's some labor involved, but not necessarily any repairs, no parts were ordered. So I think either defining that or including when a total loss comes in play will more accurately help these regulations be implemented in the day-to-day practical life, because that is one of the main issues we are seeing with excessive rates, because we're at a standstill with these companies at times, outside of our vendor agreements with our DRN shops where storage is charged, and we have a direct total loss the day of. They want to charge $1,000 or more within a few days of storage. They've done no work. It was automatically a total loss. It should never have went to their shop. Sometimes these companies own their own tow shops or tow companies, which is why it went to their repair shop. And then we're at a standstill, and the only real solution is litigation, which is what we've been forced to do. Now, if this is defined where it should be under the public rate and that available rate is available online, it should resolve a lot of problems. But if it's not, and we're arguing between whether or not it should be the local rate or the public agency rate, that's going to be a huge gap, because San Francisco, again, upwards of $450 a day for some of these shops, but the CHP rate or the San Francisco city rate is under $70 a day. That's a huge multiplier difference. So addressing that here, I think, will resolve that in a large part, in not just for our insurance company, for all insurance companies. I think that would be very beneficial. And so those were the main points that I had, that I wanted to talk about. So I don't know if there's any other comments you want me to address, but I know it was a lot I threw at you.
Oh, that's good.
She didn't ask any questions, so I just kind of let her roll.
Yeah.
That's fine. Thank you. I appreciate the
Excellent.
comments. Did
Took
you have
some
any?
good notes?
that
I'm
it?
sure others.
I have more, but those were the big ones. But I can
Follow
send
up
them
and
to
wread-
an email.
yeah, yeah.
Should I
Just
Yeah,
real
it-
quick, in your mind, who's your customer? The guy that owns the car or the repair shop that's doing the work?
are insured?
You're insured. Okay, thank you.
Thank you, Erica. Pete Bezick, California Auto Body Association.
I'm Pete Besick with the California Auto Body Association. Jack, I got a question to ask you. The first page, 3351.81A, did you talk about that?
I did. Yeah. Yeah.
I didn't hear you. That's a problem. So I want to make sure that there's a clear understanding. Exactly, you say when an automotive repair dealer charges storage fees, an itemized invoice for the storage services must be provided to the customer. There's two questions in that sentence.
Okay.
And the itemized storage fees may be included on an invoice for an automotive repair services. So the question is, this is kind of nebulous. It really doesn't tell you much about what that repair bill or that storage bill needs to have. So if I present to you or to the customer a storage bill that says advance fees, $500, a shop markup, $100, 30 days storage, $3,000 at $100 a day. Is that sufficient?
So I'll take that in different parts. First off, obviously, there's requirements on what has to be on an invoice. They have to be specific, have to be itemized too. I'm not talking about storage, I'm just talking about automotive repair. Some
Talking
of the
about
things you
storage.
listed there may not be specific, and so they would probably be inappropriate. Related to storage, though, no, I would think that it's gonna have to be itemized. I think this section probably does to be specific about what we're looking for.
Okay, how deep does the itemization go? If you were listening to Bill's presentation, you got issues for The vehicle comes into the shop on this date. The customers, there was discussion about the customer. You ask for a tear down authorization and the customer doesn't respond for several days. Then the customer finally gives you tear down authorization and you do the tear down and prepare the estimate and you submit it to the customer and ask for their authorization. You give them a certain period of time for authorization and they don't meet that time frame. So storage is going to start again. I'm assuming that the shop is putting all those dates the way they're supposed to be.
Okay.
Is that what you're going to be looking for? And if it is, you better say that.
Fair enough. I don't know that's exactly what we're looking for. I think we're just probably looking for a total number of days at the rate and then
Well, but
subtotal for,
but that doesn't tell you. See, the problem I have with that is that we're always dealing with the third party payer disputing the days. And as far as I'm concerned, the ARD should be keeping meticulous records, as Bill said, document. So that's what I'm looking for. And I think that that's what you really have to have, an itemization of the things that should be on that invoice. The next thing is, the invoice for storage services must be provided to the customer. Now, that sounds good. The problem is that the customer, generally speaking, in most cases, is a week or 10 days or 30 days away from when the storage fees actually occur. In other words, you're waiting for an insurance company to pick up the darn car and this is really common, they forget to pick up the car. And you've notified them multiple times. So now you've got that additional storage fee after the fact that they've been notified the vehicle is not repairable and you're not going to repair it. And the other is that you're telling them to come and get it and they don't. So the invoice is kind of complicated then, isn't it? Because the invoice actually is going to go to the salvage pool. They're going to want the invoice because that's what they're paying, and that's what the insurance company expects them to pay, and we'll be reimbursing them. Now, I don't. It could very well be that the ARD would present that bill to the towing company and a copy of that bill to the customer, although it would be after the fact. Put it down. If that's what you're expecting, that's what should be there. Don't leave it open to subjective decisions later on. Thank you.
that was it. Yeah, I got all the other stuff. Thanks, Pete. I appreciate it.
Thank you, Pete. All right. Saw your hand next. Going in the order I saw.
Good afternoon. My name is Frank Price. So I'm a perfect case study. Just last week, we got about 3 referrals from the bar in regards to some of our wording, which all 3 agents couldn't clarify and explain.
Are you from a repair shop or insurance company?
Repair shop,
Okay.
Yeah.
What's your repair shop?
Proline Auto Body,
Okay.
in
Thank you.
San Mateo, Burlingame area.
Good.
And it's very well so. Did they, was it a good referral? So it wasn't like it was, out of nowhere. One of the things is, that we were actually looking into is reasonable. And that's a big gray area. It creates a lot of debate, when you're trying to charge for something that you're explaining in writing, which is one of our things is we have, just to give you an idea of the storage, same thing, just like everybody else is bringing up. Our specific situation is we pay triple net on our leases. All of the leases, the commercial leases in the peninsula are usually triple net. So our building goes from 30,000 to 50,000 in 4 years. That gives us a financial issue.
And so for me to reflect our storage accordingly and very transparently, that becomes an issue because I can't raise my storage and keep fluctuating it up and based on the triple net lease, even though it's very transparent. So just understood, I know that you guys are working on it, but the other thing, one thing I'm having a major problem with is I can't charge for blueprinting. Obviously, it's a word that's not allowed, I guess, through some of the agents that were saying that even though they've been through training to charge for blueprinting, diagnosing, damage analysis, all of these things that are required by the OEM procedures in your law, actually. So even though it's required by law, by the bar, the verbiage is not recognized.
Agents you're referring to, insurance agents?
What bar agents?
Bar agent says that you can't charge for blueprints?
They're saying that the verbiage, yeah, you cannot write and have the word blueprint. And all three of them that I spoke with, and I called the local guy too. I've been knowing these guys for a while. And so conversations, I don't know. I mean, it would be nice if maybe the bar accepted a glossary. Just because you got to think about it. CCC1 is just like a Word document. You can type in anything. I could write 40, 50 lines of manual entry lines that are regarding the repair procedures of that. 30% of the items are not recognized on all three platforms that are actually working on. If I'm working on 911, Porsche 911, 30% of what I got to do to that car is not in. So it does create a problem. But of course, so far we've been getting the authorization by the customer first. We document everything up front. We're doing it before we even do any work or charge storage. So been very, very lucky. But yeah, reasonable is a big deal, and I was here to see if there's some type of clarification, something that's going to come to light where we can properly document it.
Two things, fine. I don't know if you're fine. First part, or at least not yet. The first thing I'll cover reasonable in a second. Just so you know, I suspect the problem with blueprinting is that it's not. So if you explain it in such a way that the customer can understand what was purchased, then I don't know that itself would be a problem. Of course, we do have tear down authorization. I imagine it's probably part of blueprinting. Could obtain authorization to do it.
Can I just add real quick? And
Yes, of
this is where the disagreement comes. And that it's very black and white. It's not my opinion. My opinion is irrelevant. It's if I get a certain car and I'm certified in it. Here's a perfect example. I got a Corvette. Listen to this. This is the first time in my career. I got a Corvette C8. I'm paying 100 euros to get the diagrams to put in a car bench. And my point to that is that I can itemize and write that line in there, description or download purchasing of all this stuff and with an invoice. But my point is that it's really, when you say blueprint or tear down, my mechanic, I'm told by the bar, that the mechanics have to be in labor hours, the lines, because the staff, the estimators are not the mechanics, so I can't charge a labor. But my technicians who are certified has to pull the procedures in 3 different ADAS systems. So that's negotiable, but the point is that how do you word that? And that's a very good point. That's actually my point. You're telling me I can't write blueprint because the customer doesn't know what it is. So if I put download diagrams or download schematics or download, I think ADAS system, calibration system, replacing the front windshield and all that, can I use that? And will the customer know? Most likely not. Some of these people are not car savvy, but I can print you out documents, take it to small claims court and be very transparent about what it is. And but I'm getting conflict here.
Well, I would say that I appreciate this conversation. We probably should have it, but it's about storage fees. So we'll move on to your second part, which has to do with reasonable and the reasonableness of daily storage charges, which has been kind of like taking over this whole conversation. And it's defined by 22524.5.
Yeah.
Okay.
Yeah, but then again, they don't believe it's reasonable. Agents and including insurance companies, even though my triple net lease went up to 50,000 from 30,000.
Is your storage rate comparable to other shops in your area?
Not at all. No, we're not comparable at all because the guy across the street has a 5,000 square foot shop.
Okay.
He's $5,000. So that's the difference. And again, we work with everybody. We write off days and we work with the negotiate the total thing. It's not what I'm charging. And it's more to be, I'd rather have a good relationship and have a good ethics and moral and charge what's reasonable. But I can't just, they don't understand, no one will understand what my P&L looks like. And the P&L that on a business is, there's a lot of businesses right now losing triple net monthly, so somewhere near, and so it's a big issue for someone who has to oversee it to make business decisions, so the company doesn't lose you next quarter.
What's the provision again? It can be higher or lower if it's otherwise reasonable.
That's right, yeah. All right, well, that was just it, but thank you, guys.
Thank you
Thank
very
you.
much.
Good comment.
Moderator, I hope you're still with us.
Yeah.
I know we use the virtual attendees yet, and I want to reach out since we've been focused mostly on the attendees in the room here. Do we have any public commenters on the?
We
from the-
certainly do. Let's see. The first raised hand I have is Philip Gallimore. Philip, I'm sending you a request to unmute your microphone. And you're unmuted. Go ahead.
I had some questions on how the tool would work. So in the first year, if you get the average rates and you post those, and then we adjust the rates. So let's say our rate is $150. The tool comes out and says the rate is now $100, so we lower it from 150 to 100. When we go to renew, do we have to then say, then in year 2, our rate is now $100, or can we put what we would like to charge, which is 150? Because if the tool doesn't float, then the rate will either be 100 and then keep going down. If that's like a maximum, does that make sense?
I think I understand what you're saying. You're saying that you provided information to us about your daily storage rates, and that over time they may adjust up or down, and how would you deal with that situation?
Yeah, because in the first year, you're going to get sort of like what everybody's charging. But then in year 2, it's going to be the adjusted rates, because some people who are higher can no longer charge a higher amount. And then if it's penalty of perjury, you now have to go to that average number to be reasonable. So I don't know if the number will start to not be a true average and just stay exactly stable.
I don't even really know how to answer this one except to say that, so that the average would be adjusted as we receive renewals from shops that we were collecting the information from. Probably would fluctuate a little bit or the other, but if you look at that section, it actually would require the facility to maintain whatever they tell us until the next renewal period. So I would expect that your average would not, your amount would stay the same as far as your daily storage rate. But then at the point you renew, if you go to that site and you determine it's less, I guess I would wonder why it would be less than it was before. Again, you would hope that repair facilities are actually planning and projecting the amount that they're going to charge for storage based on their expenses, their property leases, their employees, their equipment, as opposed to just looking at our average to make a determination if that's the proper storage amount for their facility or not. So I don't know if I have an answer for exactly. I don't think it's going to suppress storage fees. If anything, I probably think it would cause storage fees to go up, although I hope that doesn't happen. But either way, I hope that helps, but I don't know if I did.
No, yeah, I just if you so would you be allowed to float? I mean, I guess I'm trying to understand if my rate is 150 and the tool says 100, that might be okay depending on, what you all determine at that time, right? So if it's still reasonable within the area.
Yes.
Okay. All right. Thank you.
Higher or lower, if otherwise reasonable. Yes.
Okay. I appreciate it.
And our next commenter is Alyssa Lair. Alyssa, I'm going to send you a request to unmute. 1 second here. And it may be behind the 3 other options. Oh, you're unmuted. Go ahead.
My name's Alisa Lair. I own Johnny's Custom Auto Body in Gilroy, California. This whole situation, honestly, in my opinion, is a continuation of the honestly failed labor rate survey system that the DOI has, because all that ever has happened with that is the insurance companies use it as a weapon against us. I'm so neck deep in this very situation as we speak that I have no words. I have insurance companies that come in, we do an estimate, we can watch the car come in on the tow truck and say this thing's a total. We'll write an estimate, get it authorized by the owner, send it into the insurance company. The insurance company will run their handy dandy AI software that is religiously and consistently insanely low as far as estimates go. I have an estimate right now. I sent it in. It was a $23,000 estimate. It came back at $7,000. And then they want to keep going. And then they ignore the fact we're like, this is a total loss. We need the car, done. Get out of here. Come pick it up. Come do what you got to do. And I've been waiting 2.5 weeks contacting the insurance company every other day. What are you guys going to do? What are we going to do? What are we going to do? And then what happens is 30, 45 days later, I'm the bad guy because I want to charge storage on my very limited space. And they said, well, we're not paying that. The car was a total loss a month and a half ago. Well, you never informed us. You never informed the customer. So now I'm the bad guy, and all you're doing is giving them yet another tool. Where's their due diligence? We've informed them. Where's the regulation within this that helps the shop out? Because literally all the regulations make the shops out to be the bad guy. Never is there due diligence on the insurance company's part to actually follow through. Because a lot of the DRPs, they have a contract where they can let that, it's on them. They don't get to pay storage. I'm not a contract shop. And my space is extremely valuable. And as far as the CHP lots, yeah, we rotate through the different tow companies. The tow companies don't have to use crash wrap. They don't have to clean up the glass. And then there's another problem with that where I'm supposed to not be able to move the car. Well, what if half the suspension's gone and I got to put this thing on a dolly? Now I have to get permission to roll it across the yard? I think there's a lot of input that needs to happen with this. It's yeah, I just see it as another tool for the insurance companies to be able to not pay shops, because that seems to what consistently happens throughout all these regulations.
All right, thank you.
Our next comment is from Chris Evans. Chris, I'm going to send you a request to, let me see, Chris Evans is no longer in the meeting. Okay. Let's move on to raised hand from Andy. Andy, I'm sending you a request to unmute. Go ahead.
Can you guys hear me?
Yep.
I'd like to I'm a shop in Los Angeles, and kind of like what the lady was saying earlier, that so it's specific to total losses. My comment and my issue here is specific to vehicles that come into our facility that the insurance companies deem a total loss. So I understand that my contract and my agreement is between me and the customer and not me and the insurance company. But I don't deem the vehicle a total loss, and the customer doesn't deem the vehicle a total loss. The insurance company does. It's the insurance company's decision not to pay to fix the vehicle in most cases. The insurance companies take their time. In some cases, they don't even come out. They ask us to take the photos for them, and then they write those incomplete estimates, and they say, oh, look, it's repairable. And then, 5 days later, we have to submit a supplement, and then we have to send more information. Oh, okay, now it's a total loss. So the car's sitting in my lot for 15 days, and they're telling us that, oh, well, we didn't total the car until today, even though the car's been there for 15 days. So we shouldn't be paying for storage from the day it came in. We only owe for storage from the day we deemed it a total loss. Second part of the problem is, again, the labor rate. If we have a labor rate survey, if the insurance company is going to dictate, or insurance company or some regulation is going to dictate what we charge on a daily storage rate, That regulation should not come from the CHP because the CHP and their rates come from contracted facilities. So just like the insurance company labor rate survey cannot get a survey from their DRP contracted shops and they need to go to a free market to get that survey, then the BAR needs to go to the free market and get that same survey. It shouldn't come from a CHP or from the police garages, because those are contracted and those are agreements that those vendors agree to work for those rates, agree to work with those pricings. 9 out of 10 OPG lots in Los Angeles won't even do a local tow. They are only hired by the police garage. I cannot call them and say, hey, I have a tow. Can you go tow this car? Or, they won't do it. And the insurance company, when it comes time to pay, they say, oh, well, the police garage only charges X amount, so your fees are not reasonable and they're excessive and you shouldn't pay. We shouldn't pay this. These are just things, again, I think that if you guys are going to create a system where you're going to regulate our fees and you're going to regulate what we should and should not charge or can and cannot charge, I think that we need to take a further look into this, and we need to sit down and have a real conversation with what we can and what we cannot do and what is fair and what is not fair and what is within the law and what is without the law. There's also, I seen earlier, it mentioned that, we have to accept the check or we have to accept the credit card because Copart or IAA, these auction yards that the insurance companies hire, it's a burden on them to carry that much cash. They have to go to the bank one too many times a day because they don't want to make certain type of payments. I don't think that should be our problem on how and what type of payments we receive, because the third party vendor has to go through a hassle to go get money. But these are things that you guys need to put together. We need to have these conversations and figure these things out. Thank you.
Thank you for your comments.
Thank you, Andy, for the comments. I think it was Andy.
Yes.
We are past our scheduled time, although we did say or until close of business. If people need to leave, I certainly understand. We will be here till we hear from everyone who wants to speak. I hear there's at least 8 more commenters. I would ask if we could try to summarize those within no more than 2 minutes. We've heard a lot of the things we're hearing are comments that have been made, I think, by some of our other speakers, but I appreciate everybody's interest in wanting to bring attention to a certain aspect of the regulation. What would be helpful if there was rather than personal experiences, well, those are good, but we're trying to dive into the regulatory language itself. And if there are suggestions for language that should be deleted or added or amended, please let us know. That's the particular interest we have here with this workshop. Next speaker, moderator, please.
All right, our next speaker is Cameron. And Cameron, I'm going to send you a request to unmute your mic, and I'll give you a warning when 2 minutes is up. And go ahead.
Okay. Can you guys hear me?
Yep.
Okay. So my question is, why would an ARD be held to different rates depending on if the vehicle had been repaired or not? And then also, what qualifies as repairs?
Some of that.
We missed some of that. If
Oh, sorry.
Cameron, yeah, could you? There, you came in clear of that.
Okay. Yeah, I just put my mic up next to my mouth more.
Can you repeat it,
so,
please? Thank you.
Yeah. So my question is, why would an ARD be held to different rates depending on if the vehicle had been repaired or not? And also, what qualifies as a repair?
Okay, well, what we were talking about was related to whether a repair is done or not. If a repair is performed and completed, we're talking about when the lien arises in the transaction specific to 3068. That has to do with when a lien arises, which is after the repair work is completed. 3068 point 1 has to do with a lien rising upon possession, where no repairs are performed. Different situations. So we have brilliant and talented attorneys come to the idea that there's going to be different storage rates based on whether the car is worked on or whether you're acting like a storage lot.
So I would suggest, and now this is of course up to debate, but I would suggest that for the ARDs, because our space is limited and we do not want to act as a storage facility, I would think that it should be the same rate no matter what at a ARD, because we're not a storage facility. We're here to repair cars, and if the car is going to be here and it's a total loss and sitting, that's still taking up my space, the same as if the car came in for repairs and ended up not being repairable.
Okay, thank
That's my 2 cents. Thanks.
Yeah, I just wish, I wish, yeah, I've heard that comment before from others. And I wish I could tell you how many we, ARDs we have. I don't have a precise, number, but I know we've dealt with this matter. ARDs who are in the business of storing cars more than repairing cars. In fact, the bottom, how much did you make on storage last month?
I
Become-
have no clue.
you that.
No, I know. No, I'm not asking you that. That becomes a question that seems to be their bottom line. They're in the business of monitoring police scanners, getting vehicles over to the facility to store that vehicle and not repair it.
Oh, I think that'd be more on the CHP yards. But yeah, we don't have a tow company. We don't have any of that stuff that we work with. So we're luckily in an area where customers come to us. We've been there about 52 years.
As for your second question, which was, what is a repair? So automotive repair is defined, the Automotive Repair Act is the diagnosis and repair of the malfunction of motor vehicles. It is a specific job. It could be, I don't want to go through a list of stuff, man, but if you
But
find-
is it basically if we tear it down and we provide the customer the estimate, that qualifies?
Yeah, a tear down is a specific job defined by regulation where you get authorization to disassemble a vehicle or component to a condition where you can generate an itemized estimate to restore it, in this case, to its pre-loss condition, right? And then once you present that itemized invoice to your customer, you will have completed that specific repair that was authorized.
Gotcha. Thank you.
Thank you, Cameron.
you.
Next question, next commenter.
Okay, our next commenter is Dawn, who does not have an audio connection, but typed her question in. How long will you be collecting everyone's rates and data before you make a decision on what we will be able to charge?
Well, I think we'd be making the decision until we had a reason to make a decision, but independent of that, we would be collecting them for a period of a year before we'd have enough data for this tool to work or provide accurate information.
All right.
No, setting rate. Looking to avoid that. Next comment, question.
Okay. Next, let's see if he's still in. No, CJ. Oh, CJR, you are still in the meeting. I'm going to send you a notification so you can unmute. There you go. Go ahead.
I guess my question to everybody on this call, in this meeting, this webinar is, does anybody here think that $300 a day is reasonable storage to store a car? It's just a simple question. I live in the state of California. I have my whole life.
In some other areas of the state, facilities charge that much per day. And if it's reasonable to the shops in that area, then that's the reason.
But as a consumer, and we're all consumers, do you all think that's reasonable? $2,100 a month? $8,400 a month?
I mean, it's not for us to say.
Well, I mean, we're all consumers here. Let's be honest, right? I think if you ask anybody, and I ask my friends and family, and they think it's completely nuts. And that's just my opinion. And I'm just, asking everybody on this forum what they think.
I appreciate that, but I have an opinion I'm not inclined to share, but I appreciate the thought.
Okay, thank you.
Thank you.
All right, and next is Lorenzo Montelongo. Let me see if you are still in. Let's see. No, we lost him as well. I can read the questions of the people who are no longer in the meeting, just for the record, if you'd like me to.
How many are there? Yeah, go ahead.
Yeah, okay. So Chris Evans' questions, can panelists elaborate on the insurer not being a customer? Does the fact that the insurer is paying the bill in most cases compel additional discussion on that matter?
Yeah, the answer is no, obviously, because of the law.
Okay. Chris had another question. Does partial tear down or dismantle a vehicle that becomes a total loss constitute for repair transaction under section 3351.8.2 storage fees resulting from a repair transaction?
If he partial tear, I mean, like a tear down is, anyway, I'm not gonna, the answer is that if he completed the tear down and generated the itemized estimate for, yes,
Okay.
caveats.
All right, let's see here. Chris had another question. Is it permissible or supported for third-party bill payers, insurers, to identify resources such as rates, official police garage association of Los Angeles, to access and identify reasonable daily storage rates that municipalities in selected jurisdictions pay, and use this information in claim handling as insurers engage body shops and customers on reasonable storage rates to ensure accuracy?
I would think the answer is no, but I don't know the circumstances specifically. Having said that, what is reasonable was being charged by other facilities in the same locale.
Right. Okay. And then Lorenzo Montelongo's question was for 3351.8.1. Are you wanting the auto body shops to create a separate itemized invoice, or would you allow us to put it on the final bill with it itemized there?
The regulation specifically says it can be anyway, but it could be recorded on the final bill.
Great. Thank you. And Lorenzo also asked, if an ARD tows and repairs a vehicle, the towing fees shall be authorized by the customer on a separate form from the repair estimate. Does this mean I have to get another authorization for the tow?
Yes, and seeing as how the tow comes first, I hope you got that first.
Okay. Next question is from Jerry Benavides, and Jerry is still here. So Jerry, I'm going to send you a request to unmute your mic. And Jerry, you should see a pop-up on your computer. I'll send it one more. There you go. Okay. You're unmuted. Go ahead. Jerry, I'm not, let's see. Let's try again here. Jerry, try again.
Now can you hear me?
Now we can. Yeah, thank you.
Yeah, the biggest regulation when I put in the question and comments is basically, you know, when these shops are taking in cars, clear total losses. How somebody else is stating, you know, they see it on the tow truck, it's a clear total loss. What's their regulations of reaching out to the customer / us, the insurance, when the customer's providing them insurance information, stuff of that nature, on when to really start the storage charges? Because we do see that a lot, where a lot of these storage facility shops are just taking in cars, they let them sit for a month, and then they start reaching out to us because now they know they have a $2,000-3,000 bill. What's the regulation on that for them to reach out to us or the customer type of deal?
I think what you're asking me is if the repair facility fundamentally has a responsibility to reach out to the insurance company because a car has been left on their lot. I guess I don't know that that requirement actually exists because the insurance company isn't the customer. The customer is the person who vehicle delivered to the shop.
Okay.
All right. Let's see. And another person who apparently has left the meeting but left a typed question, Andrew Batenhorst, says the bar has already been using laboratejero.com for reviewing labor rate heroes for reviewing storage rates in a locale. Is there any explanation why this can't continue to be used? Will the proposed database allow users to update the rates at their discretion as well as view the rates of other ARDs in the same locale?
But 3 questions. First one is Labor Rate Hero is a tool that actually is being used, but it's as good as it's going to get without us stepping in to put something better together. Shops don't have to submit information to Labor Rate Hero, so it's only going to represent those people who provide information. Therefore, it can't be an accurate representation as required by our regulation. Second question was, sorry, I lost in the answer. What was the second part?
Explanation on why this can't continue, and then will the proposed new database allow users to update their rates and view others?
So they would be able to view the rates of a geographic area as they define it, but not the specific rates of other shops in the area. And
Updating their own rates.
oh, they can update the rates. Well, at least as far as the regulations are currently written, they'd have to be able to plan and project the amount that they're going to charge for the next 12 months, or at least until the next renewal period, or the rates would be set for 12 months once they submit them.
Okay, so you can't go in at an interval and change just because traffic changed.
Not as the regulations are currently drafted, no.
Okay, great, thank you. Andrew Batenhorst had another question. If an ARD owns its own vehicles, i.e. renter, loaner vehicles, or shop trucks, and that vehicle is damaged and being repaired through an insurance claim, is there any clarification on if that ARD is allowed to charge storage fees? Normally, these vehicles are for business use and are out on the road, not stagnant in a shop down for repairs.
Customer is the customer. I guess if they're going to charge themselves storage.
All right.
Shall be.
Let's see. And then Jerry, we did get a hold of Rob Wright. Let's see if Rob is still in the meeting. You are. Rob, I'm going to send you a request to unmute.
Again, everybody. Just a quick kind of a comment on the CHP thing. The storage rates, I went on the CHP site. There's 8 divisions and a total of 108 offices. So you could probably just divide that into each field office would only have to do 9. So that would give you all the storage rates. 2 was kind of a little pie in the sky request. It'd be kind of cool to have on the bar website an online tool for ARDs to determine whether or not they can charge storage and what their storage charge would be based on dates and rates. So maybe just something for the future.
Thank you for the comment, Rob.
And our last comment is from Melanie King Salgado saying, I do not have a mic, so I'll read the question out. If a vehicle is towed to a repair facility, how is it that the facility would have to secure a separate authorization? Oftentimes vehicles arrive without knowledge to the repair facility or after hours. How would a shop get authorization for towing fees if this is an action that was not initiated by the repair facility?
The answer is you wouldn't. That requirement for separate authorization is specific to an automotive repair dealer that also is the one providing the towing service themselves.
All right. Let me make sure I caught everyone, and if there is anyone else who has been overlooked, you can raise your hand by clicking on the hand icon. But it looks like we caught up with everyone. That's everyone. So would you like me to close the public comment feature?
That'd be great. Thank you, moderator.
You're welcome.
All right, I'll go back to the room. Are there any final? Yes, Walter. Feel free to come up. We heard from Walter earlier at our bar advisory group meeting on this topic, but have a seat. Introduce yourself. Yep, there's some who haven't heard who you are yet.
Yeah. Good afternoon. My name is Walter. I'm from South San Francisco, Cars Auto Body Shop. So the clear code, I'm sorry, the vehicle code is very clear. It says the insurer is responsible to pay for the storage and towing, and it still is published there, right? And also it says the charges have to be deemed only if the CHP requests to open the gate from my shop, right? Let's say there's an accident, the car is towed to my shop, then I have to deem, so the charges the daily charges for storage only if the CHP requests. But the insurers, guys, are not a CHP or public agent, right? Requesting to open the gate to store a vehicle that is a total or whatever. So, right now, I noticed like explained earlier, the insurers are removing from the settlement amounts to and offering to the shops to pay the fees. When we found these issues, and I've been reporting this to the DUI, and the DUI, Mr. Dave Solis never answered back to me. Can we still doing it, or the bar? You guys will help the consumer understand to understand how the insurer can remove this amount of money from the settlement, when they can do it, when they cannot, and to inform, well, for the consumer protection, right? So, because I noticed that this is very common. What they do is that their vehicle costs, a sample, $20,000. They, for the negligence of how they handling the claim, they owe $3,000, $4,000 on storage and labor and parts. Then they remove this amount from the consumer and they offer this money to the shop. And most of the time, I have all the documents, I have many cases, many files, many witnesses. That I can prove all those cases. When we mention DUI, they don't care. It's like there is any agency regulating right now the insurance companies. So right now they're doing anything what they can. They're requesting bar to play a role like they are consumers. So they trying to, all those codes that are being designed to protect the consumers, to protect them too. That's what I noticed, but they are the expertise on the, like the other guy was saying, it's reasonable to $300 daily on a shop or whatever to just to start the vehicle. Well, sometimes we have the vehicle in the frame machine, and the frame machine, we can make in 4 hours, we can make $500, but we have to wait on the insurer to take a decision to total the vehicle. No, if you don't belong to the network, they could take a week, they can take 2 weeks to give you an answer if they want to fix the car or not. So my question to you is, I noticed that you guys provide 6 days to respond to a claim. But I tried to find on the law, the practices codes and all that from the DOI. I don't know, I didn't see any part of what it says that they have 6 days to respond to a supplement. So if they take 6 days to respond supplement, and then sometimes they don't prove you everything. They say like, oh, you have to pull a little bit more and then we will come back. And then there will be another 6 days. So my question is what are the shops right on those cases? Because I think we have some rights too, right? So what are the rights for our shops? Because we have to pay our workers independently we fix the car or not.
Okay. So a couple thoughts. One is that I'm not gonna be able to answer all your question because we're talking about storage, and some of it you're talking about is not storage at all. Something other than that. It has to do with your interaction with insurance companies, kind of repeatedly covered how that is or is, actually might be hurting you, but it might also not be fully appropriate. So I don't have an answer for how you pay your customers. I'm sorry, your customer, how you pay your employees necessarily. But what was the other question? Was there another question?
The question is, there is some regulations of
Okay.
how the insurers have to handle
Oh,
the claims.
So it's civil codes, or I'm sorry, not civil code. There's California Code of Regulations section called the Fair Claims Practices Act where that's contained. And it talks about the idea that an insurance company has 6 days to decide if they're going to inspect the vehicle, or if they don't inspect it within that 6 days, then I guess they forego that. Having said that, we don't regulate the insurance companies. I'm not 100% familiar with that section.
No, but it's on bar.
Sorry?
It's on the section of
Oh.
the new regulation that you
Well-
guys adopt, and also it's unreasonable because right now we have tools that they can inspect the car quicker. Like we can do, like with Allstate, they have a virtual appraisers where they can inspect the car right away. But some of the insurers, in mind, you giving the chance to them to respond 6 days and then another 6 days. If I complete a repair in a month, my customer will go away from my shop and they never will come back, even if I do the most efficient job.
6 days you're referring to is actually contained within another regulation package that we did at the October Bureau, well, this workshop. Sorry, is it also on the website? No, it's not on the website, is it? He's talking about the teardown regulations, right?
The 6 days is referred to in the storage guidance page on the Bureau's website, which is only a reference document to give guidance. It's not law, it's not regulation. And in any circumstance, both yourself and the insurer and the consumer should check the actual applicable regulations. But the 6 days, it's just in the guidance to give everybody, all the users, the opportunity to see all the rules that apply. But it's not a bar regulation.
There you go. It's not a bar
Not a
law.
non-bar
It's a
regulation.
Department of Insurance regulation.
AAA is stating that right now.
Yeah.
I have an issue with an adjuster where he was saying, well, if you read bar, we have 6 days to attend the claim. Business days. Business days.
We appreciate the comments. Are there more? Well, we'll take that under advisement.
Right. The last one is, there is an idea that you guys can work together with the DUI, so that way you guys can be on both sides and more equal with the whole situation. We don't want to charge a storage to the insurance company, but at the same time, we don't want the insurance company to damage our reputation, responding late and misinforming our customers that we taking long to repair the vehicle, that we are that we don't have the skills to handle the claim or to do the rest of the repair. What we do for our customers just as a courtesy for our customers. We don't get paid for it.
We absolutely are working very hard. Sharon Taylor, who just had to leave, represents insurance companies, and there's industry representatives here. And we meet with the California Department of Insurance at least quarterly, and we're all working to try and get a compromise that meets everybody's needs. In our mind, most importantly, consumers, but you're right. We do all need to work together. It's just a very complex situation that it doesn't have an easy solution, clearly by all the comments we're getting today. But we appreciate the comments, Walter, and that's a great point. We do need to work together.
Thanks so much for giving me the time.
Can you give me your business card?
Yes, I can at a later date because unfortunately I didn't bring them with me today.
That's a good. Additional comments. It's getting punchy at the end of the day.
I'm starting to feel it.
Additional questions, comments? All right. I think we're wrapping up here. Let's see. It is now, thank you so much. It's 3:59, so we've gone a little, yeah, not too bad. 2.5 hours on a workshop. Very good. Great job, Matt. Can we give Matt a hand?
That's right.
2.5 hour question and answer period. Thank you, everyone, for your attendance, your participation, and just your listening skills to take in all of this information. It is a lot. It's going to be a lot for us to digest. We'll go back and listen to the recording. We've got folks in the room who have been taking copious notes. I've taken some myself. I know Matt was, Bill, our regulation coordinators, and others. We'll all convene to see where we go here. We'll be meeting with our attorneys as well about some of these questions that we weren't able to answer. And then we'll be looking to meet again down the road. I suspect if we can, we'll try to target another workshop in July. That may be too soon, quite honestly. There's a lot to do between now and July. And it'll be aggressive for us to be able to get a next draft out there. We'll do it our best because I'd like to get this resolved sooner than later this year. If we could get to consensus on a final package, we'll do so this year. But if it's not July, it'll be October or somewhere in between. So stay tuned. And again, thank you all for a great day, both here at the workshop and at the advisory group meeting earlier today. Thank you. Have a good rest of your week and weekend coming up. Thank you.